A slide all of us should carry in our mind, telling me tomorrow, okay, doctor, मुझे तो ये पता नहीं था that this is the law, does not make sense. It does not excuse you. Next, these are the doctors, these are the cases where doctors have been prosecuted under section 304, 304A. Incidents like fire in the nursery. The head department of pediatrics is on leave, but he is penalized and he is prosecuted and he is sent to 2 years of jail for this. These are the new criminal laws which have come in. The time is 15 minutes or 10 minutes?
15.
Okay, next. We have to realize that IPC and BNS both have given protection to doctors. Remember, 1876, when was IPC made? Even there was a protection given to doctors for the actions they do in good faith. But despite that, in 2005, Jacob Matthews judgment overlooked this fact and dragged doctors within the purview of criminal law.
Thank you, sir.
People celebrate this judgment. I say this is absolutely wrong. This judgment was perverse. Next. Because all these protections were already given in IPC and they exist in BNS. So this is one reason why doctors should never ever be in a position to be dragged to criminal prosecution for doing something for their patients and not succeeding. Next. This is the definition of good faith which is given in Indian law. Next. And our courts and judiciary are confused as to what comprises negligence, and our lawmakers too. Why? Look at the Suresh Gupta judgment. This was the first judgment which before Jacob Matthews had brought the issue of whether a doctor can be prosecuted under criminal law. And what did they say? They said that recklessness of level 4, recklessness which is level 4, and deliberate wrongdoing which is level 5. These are the only situations where a doctor can be prosecuted. But let's go to the next one. These are the actual levels where the reference was taken from. From this textbook of Medicine and Law by Alan Murray. And level 3 was knowledge. Level 3 was not included as part of a prerequisite for doctor to be prosecuted under criminal law. But look at what is given in the section 117 or section 124, that if you are doing something and you have knowledge that this thing can result in some harm, then you are doing it deliberately and you are causing harm deliberately. Whereas knowledge from where this reference was taken is level 3 and this is not part of what was given. Next. There is a fundamental principle of criminal law that crime consists of both mental and physical element. There is a mens rea and there is an actus rea. I have to have a determination that I am going to go take a knife and kill Dr. Samaria, and there is a separate thing that I take actually the knife and go and kill him. Next. This recklessness, disregard for human life and well-being is what has been constituted or what has been interpreted as mens rea in cases where doctors have been dragged to criminal justice system. Next. What may be negligence in civil law is not necessarily negligence in criminal law. But supposing a criminal court decides to prosecute you, then the civil court is definitely going to prosecute you. So this is something which has to be understood, that the bar for negligence is much lower for civil negligence and it is much higher for criminal negligence. Next. And it is the foundational principle of the rule of law that any legislation, any act should be drafted with clarity, with precision and certainty to ensure fairness and prevent misuse. If there is an ambiguity in the act, it is likely to be misused. There is a potential for misinterpretation, arbitrary enforcement, exploitation, and harassment. Next. When the laws lack clarity, they can lead to abuse of discretion, and law-abiding citizens, which are doctors here, may refrain from engaging in protected or legal activities. If I am doing ERCP, it is a protected and legal activity. I stop doing it because I am afraid by doing ERCP, I will be asked, did you not know you could cause pancreatitis and patient's death? Yes, I knew. I had the knowledge. But I had the knowledge because I am well read, I have been well trained, I have good experience. If you want to be treated by an illiterate doctor, that's a separate issue altogether. But being having knowledge, how can that be the basis of my criminal prosecution? Look at what section 100 says. Whoever causes death with knowledge that he is likely by his act to cause death. This knowledge, we have to challenge this word. This is going to be misused. Next. Again, if the act is done with knowledge that he is likely to cause death but without any intention of causing death, it is still punishable 5 to 10 years. Next. To impose section 304, it has to be caused, death has to be caused by doing an act with knowledge that he is likely. I mean, repeatedly this knowledge is coming, and I don't understand. They want doctors who have 0 percentile agreed in NEET exam. They also want us to have failed in our final exams. Because if we have passed, we obviously would have knowledge, and then we are criminals. Next. 304 section has been repeatedly applied on doctors, and these are all cases where it has been quashed by high courts. Next. It is not as if this was happening only in IPC. This is a case of section 105 applied on a doctor now recently in November 2024, which means under Bhartiya Nyay Sanhita. Next. Grievous hurt. Look at the wording. Whoever causes any permanent disability or persistent vegetative state shall be punished with rigorous imprisonment or 10 years, which may extend to life imprisonment. Now, what is permanent vegetative state? You have revived a patient from cardiac arrest. The patient's heart is beating again, the respiration is working, but the patient has hypoxic brain injury. 99% of vegetative states will be because they have been resuscitated in hospitals. So have I caused the patient to come into vegetative state? When I am doing CPR, should I do an EEG before I do the CPR? Next. Section 118, voluntarily causes hurt by any instrument for stabbing or cutting. Look at the language. I am not saying doctors will be prosecuted under will be convicted under 117, 118 or 124. What I am saying is, once the prosecution starts under these sections, the harassment can carry on for years together. And Archana Sharma is classical example who committed suicide because section 302 was applied. You don't need conviction under section 302 for the doctor to suffer. Next. 325, punishment for voluntarily causing grievous hurt. 326, this is IPC sections. Next. And look at the cases which had been filed under section 326 IPC. People tell me only 304A is involved with medical negligence. Look at the cases under section 326. And these are the same sections, which is section 117 of Bhartiya Nyay Sanhita, which will be used to harass doctors. Next. This example I have given a number of times, and I don't know the answer. I hope all the patients who are in the judiciary or the legislature are the ones who suffer from this dual thought process in my mind. And I need to do an EEG before resuscitating them. Anyway, I think we need to do an EEG before resuscitating any politician, but that EEG should be done on ourselves, that are we in our right minds to resuscitate this guy? Next. Section 106, subsection 1, of course, we have been given the benevolence of the government in that 5 years has been reduced to 2 years. Next. Again, certain agents, drugs, anesthetists are going to fall of this section. Next. Here, this was meant for acid injuries. But the terminology, look at what has been used. Whosoever causes permanent or partial damage or deformity by using any other means, with the knowledge that he is likely to cause such injury or hurt. Again, the knowledge. And this is not less than 10 years, may extend to life imprisonment. I do not want ambiguity, I do not want leeway for the police person to be deciding what section to be applied against me. Have it clear cut. Next. This medical superintendent have given an order that you treat the patient who comes to emergency free of cost. But before admitting in ICU, 25,000 has to be deposited. Patient's attendants took the patient to a government hospital. Patient died on arriving at the government hospital. Now this medical superintendent who has not seen the patient, who has not treated the patient, is charged under section 304. Criminal law is personal. It cannot be that IMA head is Dr. Bedi or Dr. Bhanushali, and I as a member of IMA do something wrong and he is put into prison. It is a personal. Next. Similarly, for giving hormone replacement therapy without informing that infiltrative duct carcinoma can occur, criminal prosecution of the medical superintendent, of head of gynae, Christian Medical College, Vellore. Next. We all know this case. Next. OT images and videos. People are very, here also the conviction. Next. Next. A perforation was done, not picked up early, though they picked it up, but not picked it up early enough. Next. And under RTI we took information. You forget 304, 304A. You give us information on how many cases you have filed against doctors claiming medical negligence and which were not under these sections. We have replies from multiple states. Thank you so very much. I need